That for the status on it.
For the petitioner, your lordship. Your lordship, I very pleased to submit your lordship that I mention this matter for the order correction. Inadvertently, your lordship, the district of the district inspector has been recorded Bakura instead of Purulia, your lordship. This matter.
Do you have the cost title?
Yes, your lordship.
Please see. DI Bankura is also there. DI Purulia is also there.
Yes, your lordship. Earlier, when we filed these matters, your lordship, we mentioned we draft that we mentioned the both DI in the petition, your lordship.
Yes.
Where the petitioner is working and where the petitioner wanted to transfer.
Right.
It is my mistake, your lordship, that I ought to point out at a time of hearing this thing, your lordship. I ought to point out this thing, your lordship, at a time of hearing.
So it was your fault?
Yes, your lord.
It was seen Bakura and that is the reason it has been mentioned. And are you sure it will be Purulia?
Yes, your lordship.
Acha.
Your lordship, kindly come to the page number 3, your lordship, where the school address and the district
Paragraph 7. Bakura will be replaced by Purulia.
Grateful, your
Yes,
lordship.
next.
Grateful, your lordship.
I'm for the petitioner. My lord, in ordering part, my lord, paragraph number 2, it has stated, my lord, it is a transfer application on spouse medical ground, but it is correct proposition is a general ground transfer application.
Paragraph 2.
Yes, yes.
Spouse medical ground.
It's a general ground transfer application. So, my lord, this part is paragraph 4 to be deleted. My lord, further medical verification.
You have specifically mentioned spouse medical and that is recorded over here.
My lord, it is old matter, my lord.
Yes?
It is old matter, my lord.
And you forgot. So it was your mistake.
No, my lord, it is my mistake. I am my lord, only this part. Otherwise, my lord, my spouse will be examined, my lord, re-examined. It will say situation is difficult. My lord.
No, at that point of time it was medical ground.
No,
Now,
not never. It is general ground. Never, my lord. I have stated in my application also status. Your lordship kindly see the
Anush
status.
Babu, এ মাসে এক Please come. The matter has been mentioned for upgradation, for correction. Mention করছে the learned advocate for the petitioner submits that inadvertently it was mentioned that the petitioner sought transfer on spouse medical ground. So, the petitioner seeks transfer on general ground. Stop. Next. In view of the above, the words on spouse medical ground appearing in paragraph 2 of the order dated 9th January 2026 shall stand deleted. Stop. Paragraph number 4 of the said order shall also be deleted. Rest of the order remains unaltered.
And for the state, our names we take to be included in the Lordship's order dated 16th February 2026. Omitted the names.
Give the name.
Yes, my lord, I am reading.
Name to be included for the state.
Much obliged, my lord.
It is the wrong name of the advocates for the petitioner has been recorded.
All right. Give the proper name.
Yes.
Name will be changed.
Tendering my approach, madam. Lord, in this matter, I am for the writ petition.
And for the corporation lord, that matter that salary has been withheld valid. The building is of G+3. Sanction plan is of G+1, and 2 extra floors were being erected. Both the 2 floors have been fully demolished. Ground floor and first floor level, there are deviations. Deviations have been partially demolished. In the ground floor, my landed floor's client was also there. Fully, the ground floor deviations could not be demolished because the entire plan building structure will be in problem. I have mentioned there.
Milord,
Ground and first floor.
Milord, no inspection has been held till date, Milord.
No demolition done?
No, Milord, demolition in respect of second and third floor has done, Milord.
Yes.
Have done. Milord, my learned friend is, Milord, mentioning regarding ground floor and first floor. Milord, no inspection, joint inspection has been made, Milord. No inspection notice has been served upon my client, Milord. How did they say?
Actually, their demolition has been done in the ground floor, and for that reason, they are staying like it.
Yeah, Milord, my case was for demolition.
And now is-
second and
Are
third
you
floor.
the owner of the house?
Yes, Milord.
Are you the owner?
Milord, I am in respect of flat ground floor, Milord. I am the owner. I have
Ground
purchased
floor. It's a multi-storied building,
multi-storied building.
and you are the owner in the ground floor.
Ground floor, Milord.
The second and third floors have been demolished.
Demolished, Milord.
All right. Now, what is your grievance?
Milord, my learned friend is saying, Milord.
Forget what he is saying. What is your grievance? Tell me. You're the
Milord,
demolition
Milord,
has
my
been done.
grievance is, Milord, in the name of Milord demolition of second and third floor. Milord, corporation is trying to demolish my residential flat, Milord.
All right. Second and third floors demolished.
Yes, Milord. Yes.
So the contempt can be disposed of.
Yes, Milord.
Yes. Please come.
But that order may be
The
regarding the salary withholding.
the report of the engineers of the Howrah Municipal Corporation dated 29th of January 2026 filed in court is taken on record. Stop. It appears therefrom that demolition in respect of the second and third floors of the subject structure standing at 79 by 2 by 5, MC Ghosh Lane, ward number 19 has been conducted. Stop. The work of cleaning the debris is due to continue. Stop.
These are there. Debris are there.
Learned advocate representing the petitioner submits that the second and third floors of the building have been demolished. Stop. Next. As it appears that there is substantial compliance of the order passed by the court, accordingly, the contempt application stands.
Milord, I am saying only, Milord, protection, Milord, with due process of law. Without providing due process of law, they shall not touch my residential house.
That is always,
Milord, kindly.
now they are protecting their portions.
Stands dropped. ঠিক আছে?
Only salary were better.
Milord, this protection, your law, I pay before your lordship for this protection, Milord. Milord, they are threatening, Milord, that our
The
my
direction for stoppage of salary of the executive engineer, building department, Howrah Municipal Corporation, the assistant engineer in charge of the building department, and the executive engineer of the demolition squad,
HMC.
Howrah Municipal Corporation, stands recalled.
Grateful, grateful.
Any further steps that may be taken by the authority shall be strictly in accordance with law.
Well,
Can disposed.
number दियो. Grateful.
Grateful, Milord.
I would to page 2 of the order.
Yes.
There are 9 lordship. Here is line 5.
Yes.
The case is the lordship petitioner or primary CPA work. Thereafter petitioner.
Use the microphone. The petitioner was.
Case was the lordship petitioner is the CPA work. Thereafter in the year 2014 petitioner exercise option. But lordship petitioner as the provident fund of the employer share and own share lordship was the custody of the government for which petitioner did not deposit the employer share with the interest lordship and requested to adjust the amount thereafter to start the petition. But the authority did not consider for which the petitioner filed writ application. In terms of the writ application order lordship, the petitioner deposited the amount. And here is lordship mentioned that 6 4.
Is the green light over there blinking?
Yes.
Well, I have the copy of the order. What do you want?
Only underline by
Underline.
lordship.
As per calculation.
Lordship mentioned the operative portion lordship. May I read full para of 9 lordship?
No, I can read it. In disposed of in the event that the petition is often refunded the employer share of contribution.
Lordship,
Did the DI make any calculation?
yes, lordship.
Where is it?
Calculation. There is no calculation sheet annex lordship, but deposited. But within the specific time, the lordship, the memo dated. Where is mentioned that within the specific time money has to be refunded.
Right.
But petitioner here refund the money in terms of the court order lordship.
Yes.
They are
Show me
22.
show me the court's order.
Court order lordship, that is the page 53.
Found that the petitioner refunded the employer share of contribution, and it can be mentioned in terms of the court's order. That will do.
Yes, lordship. Yes, yes.
Correction of paragraph 9. And refunded the employer share of contribution. 1, 2, 3, 4, 5. Fifth line. The words within the time specified in the notification dated such and such. This will be deleted. And in place of that, it will be recorded in terms of the court's order dated 29th August 2022 in WPA 4347 of 2022.
Yes, lordship. Yes.
This is all right?
Yes.
এইটা বাদ যাচ্ছে আর যেটা বললাম সেটা হচ্ছে in terms of the court's order.
But civil and from the petition lawsuit, petitioner doesn't want to continue lawsuit, then later be issued to the separate lawsuit, he wants to withdraw the case lawsuit. That may be taken into separate lawsuit.
You are the on record?
No, sir.
Dismissed as not pressed. Communication written with the records.
Great.
Time for the Para 2 of the order dated 14 November 25. It is mentioned the died in harness on 8 June 2024, but it will be 2004.
All right. Paragraph 2. 2024 shall be read as 2004.
Yes, yes.
Item 9, I appear for the petitioner minor. Small correction, the order dated 16th of February 2026. In the second paragraph, first line, my lord. The petitioner, a headmistress, it has gone down. It would be, my lord, an assistant teacher.
Alright.
Only correction.
Paragraph number 2, first line, headmistress should read as assistant teacher. অনিমের সঙ্গে
Great
এসিটা চালান তো, ওই এসিটা চালান।
But I appear for the petitioners. Hello, this is a very shocking example of a case where not only State School Service
Is it
Commission.
SLST matter?
Yes, they are there.
Why? Court room number 11. Everybody, where is Mr. Singh? Call him. Not picking up the phone, he must be busy. Alright. Alright, yes, I'm just passing it over. Next. Who is the other side?
My lord, I served. Only state, my lord, the answering respondent.
Who is appearing?
My lord, that I not inquired, my lord, I served copy of the application. Yes.
Yes.
My lord, here I am challenging the impugned notice, page 111. That was issued on 11/11/2025 against the petitioner. My lord, that is so cause notice has been given with release order. And my lord, that was posted in the notice board without serving the petitioner. If your lordship kindly say 111,
What do you do?
my lord, I am working as a, my lord, female health worker, as a supervisor, now supervisor, and my lord, without serving any notice, without giving any notice.
A regular employee of the state of West Bengal?
Yes, my lord, the petitioner in earlier occasion, the respondent authority stopped the salary, and for that reason, without any initiated any proceedings, only so cause notice in earlier occasion given, and without so cause notice given, and I made reply before the authority concerned. They did not initiate any disciplinary proceedings, nothing. I filed one application before the State Administrative Tribunal. State Administrative Tribunal rejected my prayer. High Court allowed my prayer with direction, specific direction, within 3 months. Salary must be disbursed in favor of the petitioner. That order I annexed. But in spite of that, partly salary has been disbursed. Maximum amount has not been disbursed by the authority concerned. I am working. I annex the attendance register. Every day I am working.
Alright, 11th of November, show cause notice. Did you show cause?
I replied.
Where is it?
That is page 114. Immediately when I notice in the notice board that show cause notice has been pasted in the notice board, I made reply, show cause notice, I given reply, and they received on 10/12/2025. That is track report 120.
You are not going to work?
My lord, I have not been any, my lord, show cause notice, release order.
So are you not going to work?
Yes, in previous post, in previous place of posting, regularly, attendance.
Previous
register.
place of posting, that means you have been transferred.
Well, that was, they are not allowing me to work my duty.
Where is the transfer order?
Transfer order, my lord, they did not, only straight away release order. No transfer order. Page 113. First show cause notice, then release order, that was posted in the notice board without serving anything. Page 111, my lord, kindly see, and 113. 14/10/2025 release order straight away. চাকরি করে এখন কোন পোস্ট আছে Malat release order issued on 14/10/2025. That was also not served to me. Straight away, no transfer order, nothing. And then 11/11/2025, so cause notice for non-compliance on duty orders and non-joining at new place of posting. From December 2023, they did not pay salary. Part of the salary by this order of this Honorable High Court, they disbursed. Only meager amount. In earlier occasion, same thing happened. Only so-called memorandum has been issued. No disciplinary proceeding, nothing. Only so-called. Then stop my salary. And my date of joining is 1st March 1990.
What is your submission?
Well, at first I will show you whether any transfer was there or not. But you will logically kindly come to page number 109. Fourth paragraph.
This is the release order.
Yes, Malad, the fourth paragraph.
Fourth paragraph, yes.
Fourth paragraph. May I read it down now? And whereas it appears, the petitioner initially joined under the block mentioned officer of health in BBT, PMOH, Panapur, such and such, under such and such Panchayat Committee, and thereafter transferred to the office of the PMOH, Chondidolu,
Please wait. I can read it.
block primary health center, maybe Sopur 1, 24. Thereafter, I shall one by one, I shall show you Rosita conduct of the petition. Yes. Stop. Yes.
Why are you not joining?
Malat,
There are allegations galore against you.
Malat, that is only allegation because of the supervisor and the casual worker, casual employee and the pradhan, Malat, harassing me. And
Why don't you join a separate place?
Malat, that is without transfer order, only straightway
You
release
go.
order.
Doesn't matter if it is a release order. You go and join. You go and join. Salary I'll take care. You go and join first. Just wait. You go and join immediately. Salary I'll take care. Please come. The petitioner is serving as female health worker in grade 3 in the cadre of West Bengal Nursing Services, Department of Health and Family Welfare. Stop. She is aggrieved by the action on the part of her employer. Stop. As the state administrative tribunal is non-functional at present, the instant writ petition has been filed for relief. Stop. Paragraph. It has been submitted that without a formal order of transfer, the petitioner has been issued a show cause notice along with a release order. Stop. Paragraph. It has been submitted that in the absence of a transfer order, the petitioner ought not to be transferred. Stop. Paragraph. From the documents annexed to the writ petition, it appears that the petitioner has a grievance with regard to non-payment of her salary. Stop. She approached the tribunal for relief, and being aggrieved by the order passed by the tribunal, approached this honorable court by filing WPST number 15 of 2025, which stood disposed of by the court on 18th of February 2025, directing the authority to pay the admissible amount of salary to the petitioner from December 20, 2023. Stop. The month-to-month salary was also directed to be paid to the petitioner. Stop. Paragraph. Learned advocate representing the state respondent submits upon instruction that the petitioner has not joined service despite the order passed by the court. Stop. She is on unauthorized leave. Stop. A proceeding against her is lying with the vigilance cell. Stop. From the impugned show cause notice dated 11th of November 2025, it appears that the petitioner was detailed at postpartum unit in MR Bangur District Hospital, South 24 Parganas, and a release order was issued in her favor, formally releasing her from Damdama Sub-Center, page 111, with instruction to join MR Bangur District Hospital immediately. Stop. The release order was sent by post, but the petitioner refused to receive the same. Stop. She was instructed to attend the office to receive the release order, but she intentionally abstained from doing so. Stop. The authority thereafter affixed the release order in the notice board of Damdama Sub-Center for public notification. Stop. Paragraph. The petitioner has already replied to the show cause notice. Stop. As it appears that a release order has already been issued in her favor, the petitioner ought to join the present place of posting at M.R. Bangur District Hospital, South 24 Parganas, immediately without any further delay. Stop. The competent authority is directed to file a report by way of affidavit disclosing the reason as to why the salary of the petitioner has not been paid and the period for which her salary has remained unpaid. Stop. Such affidavit shall be prepared and circulated by 6th March 2026. Stop. Release the matter for further consideration on 16th of March 2026. Stop. It will be open for the petitioner to file an exception to the report to be filed by the respondents prior to the adjourned date.
My lord, may I submit one thing, my lord? Twice he was asked to come with documents. Well, Mr. Lordship kindly come to page number 89 and 90. Well, but she didn't do so.
You prepare a report as to why her salary has not been paid and she will go and join. Alright. Affidavit of service is taken on record.
Your Honor, I am for the petition. On 16th of December 2025, there was a direction to file a report by the West Bengal School Service Commission. This is question dispute matter, my lord. But they have not filed any report.
Where is the commission? Still busy?
Lord, my seniors are busy in court number 12, my lord.
Who are your seniors?
Mr. Nag, Mr. Rahul Singh, commission.
Matter is continuing.
Yes.
Continuing. There is a direction for filing of report. Why has that not been filed?
Lordship.
Any idea?
I'll have to check, Lordship.
You have to check. Do I adjourn it for the day? For filing the report?
Just passing. Just passing. Maybe you have some instructions, Mr. Singh will be assisting the court. From item number 12 to 22, kindly, Lordship, if you get 12 to 22, same petition.
12 to 21, I see.
21.
21. Oh, sorry.
21.
Pass over, Lordship.
Alright, pass over.
To fix the matter 1 p.m. Lord.
No. He'll come just now.
Here I'm sitting. Give
Your
me
junior.
one to
Your junior will be here. You do not run around. Alright? I have seen you. Stay well.
Oh, Lord.
Yes. 22. Is it same? 22 also same. It is in a different bundle, so I couldn't follow. 22 হচ্ছে তাই। 23.
Yeah. 23 roughly.
Lord, I'm appearing on behalf of the petitioner, my lord, being led by two children.
Who's for the state?
Lord, Mr. Panda, my lord, perhaps is appearing on behalf of the state, my lord.
Which Mr. Panda?
Mr.
Who's for the state?
Sorry, my lord. Mr. Sudipto Panda, my lord.
Sudipta Panda. Where is he? Because it's recorded in the earlier order that the presence of the state will be very much required.
Yes, ma'am.
Make a phone call and come back. I'm passing it over.
Wait for me.
Twenty-four and for petition.
Yes.
My land is here.
I'm from the state.
The last occasion, my lord, there is the my lord, district inspector of school who is the pension sanction authority, my lord, to take instruction this regard, my lord, where my lord, the petitioner are the nominees.
Yeah. What is the
I
instruction?
have received a new instruction.
New instruction?
Yeah, the DI is on the line. Yes, I was asked to present virtually.
Is the DI online? No? What is the instruction?
But several times the file has been submitted to the DPPG, but every time the file is resubmitted to the DI for want of legal year certificate.
So the DI has not done anything. It is because of the DPPG that DPPG is.
I had a talk with the DI also.
Yes.
Yes, yesterday I had a talk with the DI over the telephone. So the DI was telling me that if DPPG we called for, then he is the best.
Mr. Boisho, please come. You are invited. DPPG.
DPG, I am only appearing on behalf of the director of pension and providing contempt matter, not.
Not regular matter. Who is appearing in the regular matters? The state council? State?
He can appear, my lord, he can take instruction.
So you have to contact the DPPG to inquire as to why this is being done. The name of the nominee is there. There is no
I have
requirement.
seen the provisions of the law also.
Check up, you please get in touch with the DPPG. Mr. Boisho is there. Take his help.
Where it has been written that
Lordship, I am Lordship giving up the.
Take his help. All right.
24, Lordship.
Please come. Instruction forwarded by the District Inspector of Schools, Secondary Education, Uttar Dinajpur. Dated approved. Filed in court is taken on record. Stop. It appears that the DPPG is pressing the DI to obtain legal heirship certificate from the petitioner. Stop. Acha. As the nominee of the deceased employee is clearly recorded in the service records, comma, the requirement of production of the legal heirship certificate may not be required. Stop. Learned advocate for the state respondents is directed to obtain specific instruction from DPPG. Stop. Relist 5th of March, 2 weeks time. All right. Microphone is there.
My lord, I am for the petitioner in this matter. My lord, we are unable to communicate with the petitioner. For that, I am praying for not today, my lord.
All right. Give your instruction. Learned advocate representing the state respondents relies upon the instruction
That is the GO, my lord, particularly regarding
forwarded by the Secretary of the West Bengal Board of Secondary Education.
that is the instruction, that is the GO, my lord, which provides that the voluntary retirement is permissible.
All right. Oh, relies upon the, not instruction, the circular of the West Bengal Board of Secondary Education, dated 4th April 2024. Wherefrom it appears that there is provision for taking voluntary retirement by the approved teaching and non-teaching staff of the school. Circular number ta likhe deben to. Learned advocate representing the petitioner seeks time to revert with instruction. Stop. Released 5th of March.
Okay. And the memo we kept in the record.
Certainly. Yes, next.
Memo entry, Baba.
I appear for the private respondent.
Appearance.
Appear for the state respondent, my lord, on both the business, my lord, direct state. Instruction is it generated or not? It's already generated.
And the reason for the delay in generating this?
Delay, that is the delay, my lord, the page 40
14
on 40.
40.
Absurd objection, my lord, by the joint director.
By the?
Joint director of accounts. No, DPPG, joint director of accounts.
What?
So kindly see the serial bottom. Applicant had joined in service May 1984. Appointment was approved 2008. Why? Because, my lord, the school was under the jurisdiction of South 24 Parganas. Thereafter, my lord,
But then it is good that your first date of entry has been recorded as 8th May 1984 and not 2008.
No. My approval was accorded by the DI 2008. Since I joined, my lord, in 1984, why my approval was delayed? This is the objection on the basis of the pension was detained.
Anyway, now you've
now your lordship, one thing. He is the Darwan, my lord, the group D staff. My lord, your lordship, just, my lord, kindly turn to page 26, DI Kolkata. Approved, my lord, the pay fixation, my lord, the after ROPA 2009, upon granting 18 years benefit. Your lordship, right hand side, 12,470. Right hand side. This is the 1st July 2016. Next increment 1st July 2017. Lordship got it? Now the your lordship can receive comprehensive e-pension page 35. Why I am showing, my lord, the adjustment?
Yes.
35 serial number 47. 1st July 2016, 12,260 reduced. On the basis of no pension payment has been issued. When the petitioner's, my lord, Darwan was forced to refund the amount. He refunded the amount that should be refunded by Treasury Chalan, page 37.
No, I did not understand. Page 35.
Yes.
The money was reduced.
Money was, my lord, the pay was reduced.
Yes.
Up to the after. This is the reduced refixations of now the 40,200 at the bottom. This is the last pay. PPO also on the basis of which. This is the after refixation overdone was calculated.
Yes.
Petitioner was forced to refund.
What,
refunded by treasury challan.
what can be done and when was it done?
That I am not disputing that the group Darwan, that amount should be refunded.
You filed fresh petition. This
No, this is the prayer. I am prayer of the writ petition. This refund amount should be refunded. That amount cannot be deducted from our gratuity, from his gratuity. But
When was the pay fixation done?
that was pay fixation. Well, 37 at the time of retirement, he refunded the amount.
Where is that?
37, you also can see. 25th March 2025, he retired 31st December after retirement.
25th March 2025. And
Retired my lord, the
December
2024. After refixation of his basic pay and melody.
when was this refixation done?
Refixation, this refixation done melody at the time of settling the pension. This is the pension, e-pension application page 25 onwards. This was 16 February 2024 at the time of settling pension.
See page 35, I can see e-submission date is 24th of April 2025.
That is the repension, the repension application submitted by the authority.
Yes.
That is the after the reducing his basic pay. And after refund the amount, pension process was done.
So within 1 year of your retirement, this has been
Not
done.
1 year. After retirement, he refunded the amount.
When he refunds is not important. When was the decision taken?
Decision taken, that was resubmitted.
April 25.
No. You also can see page 28. Page 28. At the top right hand side, date of resubmitted on 1st September 2025.
See, listen, if there is any mistake in calculation, in fixation of pay, the authority can always refix it.
That's good, but the amount cannot be deducted, cannot be recovered from the petitioner.
Even prior to 1 year of
Group D never.
Group D never.
Trophic mercy, Group D never. Even that within 1 year. Others,
This is what I want to know. Is it within 1 year or not?
No, this is the
calculation was made earlier. You paid it later on. That is your problem.
No. You also can see 1st September 2025. You also can see 1st September. This was calculation resubmitted on 17 April 2025.
Pradeep, the EPPO dated 13th February 2026. Produced by the learned advocate representing the state respondents. Be written with the records. Stop. Copy of the same has been handed over to the learned advocate for the petitioner. Stop. The petitioner prays for refund of the amount alleged to be overdrawn by the petitioner after the date of retirement. Stop. Paragraph. Learned advocate representing the state respondents is directed to file a written report, file a report disclosing the date as to when the error in fixation of pay of the petitioner was detected and whether the petitioner was at all intimated for refund of the amount allegedly overdrawn by him.
That has been page 27. Page 27, that has been refixed 11 February 2025. After that, 24th March, he refunded the amount. This was done by the DI Kolkata.
Alright, let him file a report.
Yes,
This is after your retirement. Yes, let the report be prepared and circulated by 13th of March. Released on 23rd of March.
Will be direct the authority to disburse the amount on the basis of
Yes.
the online ballot.
23rd. Acha. The
4 and 5.
The amount mentioned in the PPO shall be immediately disbursed in favor of the petitioner.
May I may I indulge one more item number 25, just item number 25, my other side is there, my lord. I just want
Just wait. I'll take up 27, 28 and come back.
that, my lord.
27,
State
My lord, board has filed a report, state has not.
for extension of
and so on the prayer of the learned advocate representing the state respondents, time to file the report stands extended
by 1 week.
till 2nd of March 2026. Released on 16th of March. A report filed by the board in court today be written with the records. Stop. It will be open for the petitioner to file exception to the reports prior to the urgent date.
I have already served the advance copy of the report.
All right. Yes.
I mean, so he reported
25 you said.
Lordship. In another matter, the coordinate was directed to file a report to Lordship. This is that.
File it.
This is a matter of 2024.
File it. Yes. 25. What were you mentioning?
My lord, although the time is taken because of that, my junior take the time, but in the meanwhile, my lord, I got a document that in that particular school, my lord, in the year 1999, my lord, a teacher appointed through SSC, my lord, may I handed over that, my lord.
Teacher appointed through SSC.
SSC, my lord, kindly see, my lord. This is.
So, what is your submission that the government should take?
Yes, my lord, that's my, my lord. My lord, kindly, I will give a copy to my learned friend, my lord. Take instruction in this regard, my lord, whether.
1999.
Yes, my lord. Because of that, my lord, throughout that period, my lord, since inception, my lord, this school was a minority institute.
This is Rohutara St. Thomas.
Yes, kindly turn my lord next page. Kindly turn my lord very next page.
Yes.
Appointment as an assistant teacher, the same teacher. So, my lord, get appointment, my lord, through SSC.
अच्छा এটা রেখে দিন তো ইয়েতে রেকর্ডসে
Record it, my lord, because of that.
Learned advocate representing the petitioner submits that
If possible.
the West Bengal Regional School Service Commission appointed an assistant teacher in the Rohutara St. Thomas High School, and accordingly the petitioner may also be considered for posting in the said school. ঠিক আছে? Learned advocate representing the state is directed to revert with necessary instruction on the urgent date. See if the state has any entry over there. Next. All the Passover matters.
Extremely grateful, my lord. Extremely. 29.
Item 10. Item 10.
Yes, item 10.
Yes, my lord, I appear for the petitioners. Sir. 10 to 15 minutes. My lord, all have been served. But this is one of the very shocking example that apart from illegality, how inhuman the state, the board and the school service commission, they have done. 12 of them were the
Is
petitioner.
the green light blinking?
Yes.
Green light is blinking. The other one?
Now what?
All blinking?
Yes.
Yes. It's still. So 11 of the petitioners are visually challenged. Lordship need not see that for the time being.
All right.
Get it ready. 11 of them are the visually challenged, one of them is hearing impaired. All of them got the job as an assistant teacher in 2016. Now, Lordship may kindly, like all of us, we can visualize that even for a visually challenged person, it is a 10 times struggle compared to any other persons, even for a, I can say, even to go for a toilet and that. In fact, there was also, they had to go petitions that they are entitled and they are competent, all were done. Now they were serving, no difficulty. Now they also faced because of the Boishaki judgment. What they have done in the Boishaki judgment, two things are there, two important things. Number one is that all of them would be able to participate. If they want, they can give a concessions. I am not concession part today, not for interim purpose. Now, what they cannot do based on Boishaki and subsequent Vivek Pariya is that, like I give you one example. I have just made just a chart based on their data, which is they have created a bottleneck, which is absolutely inhuman. I will kindly see if I will give the respective page numbers where from I have got it. Before that, 2016, my lord, in Bengali, out of 1,358 vacancies, 61 they were appointed. I have annexed also the final list. 61 of them, and in HI, VH is visually handicapped. Still, they use this word, and in hearing impaired, 35. So total was 96. Now this they have kindly see the drastically. This time the vacancies has gone up. So up, for the purpose of up, I am not saying anything for interim prayer, because I am entitled to under 4 that whatever extra is 1,666. This is the vacancy has gone up. So out of that 1%, that is 16.6, and 1% for visually challenged, one for, so 32 from new vacancies they are entitled. Today I am not even for that. I say that 61 of them are serving. You cannot reduce 61, because after first SLST this is the second SLST. If you reduce the 61, then you are creating a bottleneck in the whole competitions, and that's the clear bar by Vivek Pariya. That's an adverse effect, and precisely that has been done by the state school service commissions. And kindly see, my lord, this is in Bengali, and if I can give the may I show it? I mean, what they have done, my lord, in visually challenged, there are signs they usually cannot, or very few of them they can do the laboratory. So all of them or most of them, they study in this literature, history, theory, all, where laboratory things are not there. Now these are the subjects they were working. I can understand that, okay, that may be a subject, whether a new vacancy, still I am entitled to 32 more. I am saying for the timing for Bengali. But how can 61 who are serving, that can be reduced? Now, 2 points are there. Number one is the Honorable Supreme Court says that if you want, you can give a concession for the physically handicapped persons. It's a matter of discretion. They can take a stand. No, we don't want to give a concession. Right. You may not give a concessions, but you cannot do something diametrically opposite to concessions, that reductions of the number of vacancies. Can you see the history, the next page? There, total number of vacancy was 988, reserved BH was 38.
So 67 reduced to 36.
Yes. And geography. This is so, usually I don't use the word. This is not just illegal. I can show the laws. I have the judgment also to show how drastically illegal. But this is inhuman also. Any authority having seen 61 of the visually challenged persons, they are working. Now, whether I can help them to do something little more, that's a different thing, but at least I would not do something to make further obstruction in their life. The interim, may I show the relevant pages where from I have got it, so that.
No, you must have collected from the data.
Yes, 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 it is.
No use.
It is.
All right.
Today what I am praying is, I am seeking a meet path. Meet path is this. There is a path of I am entitled to of the new vacancies, 1,666 in Bengal.
You calculate the percentage.
Yes, that would be much more. Kindly take the percentage, 23,000 in 9 and 10. Straightway, that 1% becomes 230. 2% becomes
260.
260.
460.
460. Now, that finally, definitely I will press on that. But today, I am seeking before your lordship's kind.
Where are you positioned now?
I am out of the list.
Not even in the interview list.
For the last 7 to 10 years or 6 years, my lord, in fact,
you were serving.
My lord, in fact, I can only say only one thing.
Why are you so late?
My lord, to say if for 9-10 the list is there. Now my names are not there. Kindly, under the law, after the interview, they have to prepare a final vacancy list. So whatever they have done, these are tentative. That's the law under 7.
Final vacancy list has not been published in respect of
law requires that this is not a final vacancies. The law is not that. Law is there are 2 stages. One is an indicated vacancies, and at the interview stage there are still final vacancies.
That has not been published.
No, that's the time. That's the right. Today I am seeking this. At least protect the number of vacancies which was there in 2016 for VH and HI.
Alright, I get it.
The other part that can be decided at the final stage.
Who's for the state?
Mr. Shishanu Bandwal, Senior Standing Council is engaged on behalf of state.
Nancy or anybody of his, anybody of his
I can show the Supreme Court saying clearly total number of vacancy. Thou exactly I have 2000 is a larger bench judgment. Paragraph 2013 10 SSC 772. Paragraph 30. Even illustration has been given at paragraph 38. Kindly have a look at 38. How this has to be materialized.
Paragraph 2. 13, 10,
Paragraph 38. Well, this was under the old act when there was 3% reservations. Now it has gone up. Even then, to illustrate, if there are 100 vacancies of 100 posts in an establishment, the establishment concerned will have to reserve a minimum of 3% for persons with disabilities, out of which at least 1% has to be reserved separately for each of the following disabilities: person suffering from blindness or low vision, person suffering from hearing impairment, and the person suffering from locomotor disability or cerebral palsy. Appointment of one by, I need not, even at the end of the paragraph it is also said. Now there,
the for the reservation list that you placed
yes,
in the other matter.
That is the roster. Roster will not solve this problem because roster is the mechanism.
Yes.
This is the case of total number.
Vacancies.
Yes.
Right. So,
what they might have done, what I think a complete non-application of what they might have done. These are the subjects where the visually challenged they usually do. They might show some subjects in science which will remain vacant because there will be no persons. I do not want to enter into any aspect. I say that in Vivek Paria you cannot affect. I say that paragraph 49 you also to read concession at least to make a neutral view. So if in 61 of them were there, you don't reduce 61 to 38. So today I am seeking,
And the vacancies are reported by the board.
but this is something what I find is what they I have used in other matter in SC/ST that mess. I take responsibility to say that this is another mess they have done. A complete blunder.
They should work in tandem. See, one reporting vacancy, because the commission will say there is no reporting of vacancy by the board.
Yes,
So
we
I
can't
cannot
do.
do.
Yes.
And then when you place them, they say that the roster position is not such that the candidates can be placed over there.
Yes.
So the whole thing is going round and round.
Yes.
There is no relief to these type of candidates.
I can only say from my personal experience, because this was our court. The state of West Bengal took a decision saying that how a blind person can become a teacher. We can't allow. Tomorrow if the blind wants to become a pilot, that's the saying of the concerned minister. Then the matter was heavily fought out by the Honorable Division Bench in a public interest litigations. Thereafter, my lord, after they won in the matter, they started becoming a teacher. Large of them could have become bigger.
And here,
Yes, you didn't get the vacancy.
may I?
Yes.
The 2016 selection process, the roster was made school wise. We kindly see from this table only. Out of 3024 vacancies, under there is a table inside the petition also. Out of 1358 vacancies, 64 were earmarked for only one category, visually impaired category. The percentage was 3%. Each reserve, 1% each reserved for visually impaired, hearing impaired, and locomotor disability candidates. So, 1% should be out of 1300, 13 candidates or 14 candidates. But it was reported 61. This time, the roster was made central. The roster is prepared and maintained by the board, which is the disciplinary authority, and this 1% ratio, which is also there in the new act, is strictly followed. What is not being showed to your lordship? Kindly see the writ petition, paragraph 8, page number, page number 13 of the writ petition.
Yes.
Lordship, table which is prepared, that is to prejudice. Why I am saying it? Because out of 1375 total vacancies, the petitioners are compiling only those category vacancies, male female category vacancies. They are not compiling female vacancies. So the number will be less and it will prick the eye of anybody who will see. Out of 1375, 61 was there in 2016. It is much beyond 1% reservation. Now, in 2025, they have said the total vacancies is 3024. So ideally 1% is 30 vacancies. They are showing 21. This will pick the eye that the percentage is not followed, but the catch lies in the column just above that. It is only for male female co-ed school. Kindly takes the data from which they are claiming, our data from which they are claiming that they have prepared it. It is at page number 510. It starts from 510. Hello,
Yes.
Kindly see, it's a bit black in the scan.
61 is there.
1134 total vacancies under the male female is not 3055, which has been shown in the table at page number 13. It's 1134, and out of 1134, the number of vacancies for PHVH is exactly 1%. For PHHI, it is again exactly 1%, as mandated by the Act.
One percent of what?
1% of the total vacancy of that particular category.
I have exactly taken that figure.
They have said the total vacancy of entire subject, and then then they have shown the number of vacancy category wise. Only male female category wise they have shown to your lordship.
They are not showing the entire vacancy. The entire vacancy of that category will be 1% of the total vacancy.
Yes.
If we add everything,
Right.
male, female,
Yes,
everything.
Yes.
Now there are some categories where the first roster in roster the first vacancy point for the physically disabled candidate is the 12th vacancy point. Your lordship was shown on the last day. So in any case, it's a new process and the roster is being made for the first time. So in any case where for particular category where there is less than 12 vacancy, the vacancy will not be earmarked for the disabled candidate, because under roster the first, second, third, fourth, until we reach the 12th vacancy, then only it will be earmarked for a disabled candidate. Then when we reach at the 32nd point, it will be earmarked. So the percentage may be slight off. Like for 2000 candidates there may be 18 vacancies, or for 10 candidates there may not be any vacancies, because it's being made for the first time. In the next selection process, the 11th the vacancies will be categorized again from the 11th roster point. So under the 2016 Act, we are strictly following, the board has strictly categorized the vacancies as per the 2016 roster. A matter is pending before your lordship on that aspect, and affidavit has been filed.
Yes.
Same aspect. The blind persons, the Blind Teachers Association of West Bengal, they have challenged the reduction of vacancies much before. They are coming much late after taking part in the selection process. They have challenged it in August. And the board has explained how those vacancies are categorized roster wise. Board has given detailed data.
Public interest litigation.
No, before this court.
Oh.
It's WPA 2879.
All right.
Learned Senior has filed an opposition. We are not using an opposition because we don't have anything to do in this categorization.
Right.
So, the submission which is being made.
Is it wrong to submit that 61 total 96 candidates were there from the chart that has been placed? 2016 96 candidates who are physically handicapped were given appointment, and now the reservation has come down to only 58.
2016 96 candidates were there because the rosterization was done by each school, so it was not uniform. In my school vacancy, I'm doing selection from 1980 or 1950, and as per my roster, the VH or HI candidate will get. In another school, another roster is being followed. Now roster is centralized. We have to see it on the pretext of the 2016 Act and the mandate of Section 34. That for each category, whether we have allocated 1% reservation for each particular visually handicapped or hearing impaired, these two kind of persons are before your lordship. So whether that has been violated or not, if that 2016 Act has been followed stricto sensu,
Assuming you follow it, assuming if there were 96 PH candidates and now it is 58, will it not be a problem for them?
it will be, but the law has to be followed. We cannot increase a vacancy because it will. Increasing a vacancy in one category will impair.
Decrease vacancy in the regular
candidates
category.
are not.
This I can understand.
That is the predicament which the authorities are facing, because we have to. People are saying that we have reduced vacancy.
How are you following with Vivek Paria?
Vivek Paria says that the 2025 rules cannot adversely affect any of the untainted candidates.
Right.
The 2025, it does not say that the 2025 rule has to ignore every reservation.
No, not at all.
Because kindly visualize, in 2016, the EWS vacancies were not there. The EWS categorization came in 2019. We have to follow that. In 2016, 4% reservation was not there. It was 3%. But category wise there was 1% each. So 25 rules are not impairing their candidature. Their candidature is being impaired by the
affected.
Right of Person with Disability Act 2016.
Their rights are being affected by virtue of this whole thing. One who was in the service,
they are being affected by operation of law. One aspect was there. My learned senior argued it in July in Vivek Paria case. What happened? The NCTE in this petition also there is a pleading. The NCTE guidelines in 2016 allowed 45% candidates with 45% marks to apply. In 2025 it was increased to 50%. We had adhered to that NCTE guideline. Supreme Court on 21st August, 28th August and 25th August on 3 specific orders says that you cannot affect their rights by the NCT change NCT guidelines. But my lord, with this aspect, whether their rights can be affected by the changed rules of reservation or the changed roster, this aspect has not been adjudicated by Honorable Supreme Court, my lord, and that is why we are bound to follow the rules which are in existence today. But another pleading has been made, though it has not been placed today by my Amrita Sinha, that we have to carry forward.
It's the whole thing that he has submitted. He seeks for an interim order at least to protect the service of his candidates.
To that interim order aspect, but he wants increase of vacancies.
No. I don't want increase. I don't want increase in that sense. That is
But
the
the
That was not the submission made. I have not opened the brief.
Look, now the interim order which Madam Sinha is seeking is to stall the counseling and appointment for those particular categories and to recategorize the vacancies so that they can be accommodated and then complete the pilot. If we have to increase the vacancies ultimately at the end of this proceeding, pilot, then the persons who have already been selected, they will not go out of the list. Under the increased vacancy, they will be accommodated. So, today there is no scope for any interim order as such, because ultimately, until and unless those vacancies, whether they will be increased or not, it can be decided. Their right will not crystallize. They have been rejected at the preliminary stage. So, if there is more vacancy, then we will be able to solve them.
The calculations that
Yes. My lord, first, I would appreciate my learned friends' wonderful submissions. It's an independent, nothing to do with this case. Can we come to page 510? There.
But there is a report from state in this regard. So,
I show it thereafter.
yes,
Can we take side by side the chart that I have prepared?
yes,
First, it is Bengali. There is no dispute.
Bengali,
Now in Bengali, I put a question to myself. Kindly serial number 6.
yes,
In Bengali, 61 of them were there. Kindly see my chart. I have taken, and this is coming from the final panel. What is the page? 497. I have taken from that. So that is the final panel. So 61 I have not tinkered with. This is the correct figure. Now kindly see then PHI 29 male female and only female 6. So then I have this become 35. Kindly see what is my figure 35. So in 2016 in Bengali 61 visually challenged persons have been working from that, and 35 HI persons have been working in the reserved category. Now kindly see 2025 serial number 6. 61 has become 21 and 21, let's also add 8 because 8 is female. So 21 and 8, it becomes 29. Can you see my figure? It is 29. And same thing, HI 21 and 8, it is 29. So which means this is an absolute violation of the Vivek Parya, clear cut affectations, clear cut making a bottleneck.
but then if you make the percentage of 3024,
Now 3024 is, kindly see, this is one more interesting, which I will place in the final hearing, but today also. Now 2016, this 61 has come when total number of vacancy was 1358. This 1358, because they have clubbed, it was 1358. When 1358 is the total number of vacancy in Bengali, 61 of them, they are working. Now this 1358 has been gone to 3024. So there is an excess, addition of 1660. I am not seeking any interim out of that. I say law says under 34, 1% on that for each category, but that can be decided later. But today to reduce this 61 who are serving and asking them to compete with 29, which is a bottleneck, but that is
what can the interim order be passed?
the interim order today I am seeking is this.
Not to disturb your service.
Clearly clarify that this order is not to stall the process,
Yes,
because
that
they
is
will
correct.
have prejudice. Kindly record that 61 persons were working as the visually challenged based on their records. Now that cannot be reduced because of Vivek Pariyar, page
529 relevant.
Kindly come to page 529. Or Lordship, do not go to that. Kindly take this one. The last
To disturb your service for the time being, I think this will be.
I only think that because what will happen, all I want, what could be, I was trying to understand what could be the counter logic of this case, because 61 are the working, they cannot have a number, anything below 61.
Should not be ideally because
It is not a rocket science, it is not a rocket science, it is not a, they have
yes,
blundered the process.
it can be understood when the vacancy has increased, why does the reservation come down?
I'm not seeking that give me 1% of the increased one. That can be final, definitely I will ask, that is the requirement under 34. I say protect me for what was there already under 16, only that part. Kindly see why this should be protected. Kindly come to the last page. But are given separately, it's also part of the records. Candidature of the 61, it cannot be affected
By the new rules.
Yes.
So by the new rules,
Yes, correct. This, what I'm trying to say, they have affected this by application of Rule 7. Rule 7, there is an entire mechanism that first there has to be an indicated vacancy, and at the interview stage there should be a final vacancy. Now final vacancy they have not done yet. Now all I'm seeking that kindly protect the number of vacancies which were at least there for the reserved category in the visually challenged and the hearing impaired. And out of the new number of vacancies, that is 1666, that part I'm not seeking an interim today. Even I am entitled to 1% from that. But I am failed to understand, just by saying we have not done it, somebody else done it. No matter someone has done it, no matter it has become central, how the number can go down? Because it has to be category wise.
The petitioners are, my lord, physically
report has been
challenged
filed
on behalf of state. It has already. Oh. The petitioners are physically challenged candidates. Stop. They were appointed in the 2016 recruitment process and are competing in the 2025 recruitment process for being appointed as assistant teachers in classes 9 and 10. Stop. Their primary allegation is that the vacancy reserved for the physically challenged candidates have been brought down drastically from the earlier selection process to the new one. Stop. From the data that is available in the public domain, public domain, 96 physically handicapped candidates in the visually handicapped and hearing impaired category were appointed, when the total vacancy in the subject Bengali was 1358. Stop. In the current recruitment process, only 58 Seats have been reserved for the visually handicapped and hearing impaired candidates out of the total vacancy of 3024. Submission is that despite increase in the number of vacancies, of 1666, the reservation for the physically handicapped ought not to be reduced. Stop. It has been submitted that the act of the commission is contrary to the decision passed by the Honorable Supreme Court on 26th of November 2025 in the matter of Vivek Paria and others versus State of West Bengal and others. Stop. Prayer has been made to provide interim protection to the effect that the number of vacancies available in 2016 should not be reduced for the time being till disposal of the writ petition. Stop. Paragraph affords its submission of the petitioners is opposed by the learned counsels representing the respondents. Stop. It is the specific submission that the percentage of vacancies reserved for the physically handicapped candidates are strictly in accordance with the 2016 Act. Stop. It is denied that any vacancy for the reserved category has been reduced. Stop. Next. A written instruction forwarded by the Commissioner of School Education signed on 17th of February 2026 filed in court is retained with the records. Which mentions that the vacancies were categorized by the West Bengal Board of Secondary Education and forwarded to the Commission. Stop. The Commission has acted accordingly. Stop. Paragraph. Learned advocate for the petitioner has also relied upon the decision passed by the Honorable Supreme Court in the matter of Union of India and another versus National Federation of the Blind and others, reported in 2013-10 SCC 772. Paragraph 38. Wherein the Honorable Court was pleased to cite an illustration. Stop. Paragraph. I have heard the submissions made on behalf of the parties. Stop. Whether the reservation has been made in accordance with the rules is to be adjudicated. The respondents are directed to file a report by way of affidavit disclosing their stand. Such report shall be prepared and circulated within a period of 4 weeks. Exception, if any, may be filed within a a fortnight thereafter. Stop. To mention the matter for hearing immediately on conclusion of the aforesaid time period. Stop. As it appears that as many as 96, no, as it appears that the physically handicapped category candidates, handicapped category untainted candidates, who were appointed pursuant to the 2016 recruitment process are still in service, the commission is directed not to disturb their service for the time being. Stop. The commission shall also not take any steps which is contrary to the direction passed by the Honorable Supreme Court in the matter of Vivek Paria, wherein the court clearly held that the untainted candidates in the past selection process be not adversely affected by application of the new rules. Stop. I think this will be suffice, because if any decision direction is passed upon them to take a decision whether to increase or decrease, then that cannot be done.
It has to come from somewhere.
It is. The final vacancy list. Alright, if it is there, it is there. So I am not interfering with the vacancy right now. Just do not disturb their service for the time being.
31st of August. My prayer would be
not 31st. If you complete it prior to 31st, then their service goes.
that's the reason that somebody will be appointed there. But if they are not appointed, they cannot be removed.
Right. Keep this in mind and let these persons work for the time being and let a decision be taken.
Postpone that 4 weeks because I'm making this humble prayer. It is quite
So many matters are fixed. How can you expect? As it is, I can appreciate Mr. Singh's effort. He is working in war footing to prepare the affidavits, and they are coming on time, barring a few. They are coming on time. So do not put more pressure on him. Let us see how soon we can deliver a judgment.
kindly allow me, there was a mistake in the synopsis. A different synopsis was brought in. We circulated the
leave granted to the advocate on record of the petitioner to
for a supplementary affidavit which has already been
prepare a supplementary affidavit
just
incorporating the correct synopsis which has gone down wrongly in the late petition.
Well, I have last prayer. There is another blind person's matter there. Your lordships kindly tag this matter with this so that it can be finally decided.
Give the number. If you can use the same affidavit, then that will
we have not used. May I give the number?
Yes, please.
কিন্তু আমাদেরকে তো রিপোর্ট দিতে বলবে না
Let this matter. When is this returnable?
A returnable date is over. It was for 11/12. Returnable 19/11/12. All were there.
It's over.
That was there.
Let this matter be tagged along with WPA 20266 of 2025. Blind Persons Association and others versus the State of West Bengal and others. এখানে আছে।
Are deeply obliged.
Yes, service is taken on record. Supplementary তে ফাইল করে দিয়েছে
টোটাল ডিরেকশন already filed
supplementary affidavit filed in court incorporating the correct synopsis. Leave it granted,
this হয়েছে
to file, not prepared to file the supplementary affidavit incorporated. Wrongly in the yes. All right.
কৌশিক সরকার এয়ারটেল করে বুঝিতে জানা করছি সবকটা এয়ারটেল করে দিতে 12 my lord, I am for the petitioner, my lord.
Report to reading it.
Just there was a direction to file a report.
We'll file a report, by Monday. Now the report is ready, for some, we have missed, we have not affirmed it. We'll affirm it and give it by Monday and let the matter be taken up on Wednesday.
On the prayer of the learned advocate representing the commission, time to circulate the report stands extended till 23rd.
Please.
Released on 2nd of March.
Only one thing, my lord, although they have not objected, my lord, but some part of the paragraphs are in Bengali, the translated. I have prepared a supplementary affidavit with the translation. They have not objected, but if your lordship kindly allow me, I shall file the supplementary.
If it is not required, then do not file, because the documents are piling up like anything.
Only one. Kindly you have fixed matters on second. Second is little uncertain. I do not know. Earlier lordship, I have requested with the lordship. Second, in between two days holidays,
Second is the combined list coming out. This is the reason. You can seek adjournment. It's not the court.
Yes, he will not go anywhere. I am. Be rest assured.
If adjournment is sought, it will be allowed. But then, since the combined list is the reason.
No problem.
Second.
Supplementary.
Yes. Is the supplementary required?
Lordship.
Appeal court তোমার না translated
Required?
Yes.
Keep it on record.
Bengali supplementary.
Next.
Next same order be passed.
Next also, my lord, there was an order to
File report. In all the matters, there is
no, the next one.
There is direction 13. All right, same order in 13.
Matter made written upon second.
Supplementary filing?
No. This
No supplementary over here.
Second March.
Item 12 and 13 direction is the same without the supplementary.
my lord, in this matter, my lord, I have filed the deficit court fees, but it has not been recorded in the previous order. May I file afresh?
If it is showing in the CIS,
It is
no
showing.
problem.
3 petitioners are here.
Yes, 14.
My lord, 14, my lord, I am the petitioners. This is for subject geography. Against one question, my lord.
53 petitioners.
Petitioners are against one question.
Everybody against one question.
Exactly. Everybody against one question, my lord. My lord, I have relied upon 22 books, each of which is ISBN number.
2. And
My
you
lord.
given 22.
Yes, my lord. Because the mistake is in this question is such, my lord, it needs your lordship's consideration, my lord.
How
My lord,
can the court consider?
lord,
What is
regarding-
the question?
my lord, only one
Did
thing.
you raise objection at the
Yes,
first
yes.
stage?
I have raised objection in the preliminary stage, as well as the persons who could not raise objection, my lord, they have filed, they have sent email objection also, my lord, that I have also annexed.
Please show. Which question?
My lord, paragraph number 9, page 16. Another thing, my lord, I have prepared a supplementary affidavit. I have already circulated the Bengali translation.
Questions? Yes.
In this question, my lord, we are saying that both answer option is correct. The answer option chosen by the commission is also correct, and answer option chosen by us is also correct. Well, this is such a question, my lord, where two answer option can be correct, and reliance is placed by us upon 22 books. I have annexed all the photocopies of those books, my lord. I have objected to these questions also at the,
What is the question? Please show once.
my lord, question number 14, bottom at the page of 16.
Why is it easier to set up a thermal power plant compared to a hydro power plant?
Yes. They have said that the answer option C is correct. I am saying C is also correct, D is also correct. And books relied by us is also saying so.
What according to the authority, C is correct. Experts say C is correct.
Experts say C is correct, and expert relied by us is saying D is also correct. Here we are not saying that C is not correct. I am saying C is correct, but D is also correct. The nature of question is such that there can be two answers possible to answer. Right?
Will the court believe the candidates or the court will believe the experts?
My lord, the court may, my lord, if your lordship, if I can demonstrate before your lordship that there are
Show me one of the authentic documents that you are relying upon.
Starting from page 270. And one more thing, my lord, in this subject, my lord, against 5 questions they have answered all. Against 5 questions,
Marks have been given
yes,
to
marks
all.
have been allotted to all, but those are not necessary. I have challenged that also.
217.
Yes, my lord.
217 is the question paper.
270, my lord.
270.
Page 161. Inner page 161, my lord, the running page 272. The economic conditions.
Economic geography. 270.
270, my lord.
Yes.
Your lordship will find the ISBN number in the next page, 271.
All right.
And the probable answer as per our contention is at page 272.
Yes. Which portion?
Economic conditions, market. From the bottom, my lord, paragraph number 2.
আলি তুই যেটা বলবি যে 5 নম্বর দেওয়ার জন্য দিয়েছিস সেটা তো প্রেয়ারে নেই।
Where is it? I do not find anything with regard to hydel setting up of thermal power plant.
Kindly see the question once more, my lord.
Yes.
The
Why
question
is it easier to set up a thermal power plant?
there can be many reasons.
No, you show me in page 272. Where is it mentioned? Where is the expert report? Is it annexed somewhere?
No, my lord, there is no such report. This is coming for the first time.
This is actually correct.
My lord, kindly see the geographical conditions.
Things which need to be pointed out. You know, apart from anything else, please come to page 29. And he just now made a submission that someone has been awarded marks against questions to all.
5
questions.
Marks
That is also
all.
under challenge. And I do not find it in the first place. Second,
that is
No,
not
that is
under
not my
challenge.
clear. I have
Is
said
it under
that
challenge?
there are 5 questions where they have awarded marks to all which are not necessary.
That is
Like
not
my
under
lord,
challenge.
like my lord, they said which are the live volcano. 4 options are there, but 3 which are the amongst these 4 volcanoes which is not the live volcano. So amongst the 4 options, my lord, 3 are live volcanoes, but they have awarded marks to all.
It is the expert's choice. What can the court?
There are 5 like this, my lord.
C, prayer C.
Yes.
All these petitioners for verification except petitioners number 9, 19, I do not understand what is the meaning.
Because they have been called for verification, that is why.
They have crossed the verification stage. Now, if they get more marks, they get a better chance at the counseling.
All this has been aborted in the petition also.
This matter, I request your lordship to kindly wait for the outcome of the division bench, because kindly sees here it's a logical reasoning issue.
No, it's the expert's opinion, but then how the expert has dealt with the objections, this only the court wants to see. The court doesn't want to see anything else. He says he has relied upon 22
books,
authentic journals. You may have 220.
I also do not know.
Yes, exactly. So the expert, whatever the decision the expert has taken.
And as I had submitted to
You
your
have already observed in some of the matters, my lord, when they have engaged the experts by way of an email, the supporting contentions submitted by the petitioner has not been annexed. Yes.
I have seen that.
My lord, same issues, my lord. There is another writ petition which is filed by on behalf of bike line relating to the same questions. Apart from whatever.
Same question.
On the same question, my lord.
How many objections were there in that question?
Only one.
7,070 objections.
My lord,
That means there is something wrong with either the question or the answer.
Objection was wrong and out of syllabus. That is not multiple. Majority objection was
out of syllabus.
Question is wrong or out of syllabus.
My objection.
That objection is 7070. Out of which majority is this.
If that be so, then the expert may not have gone into the proper question also.
In the whatever email, there were parameters which were indicated. For which
you create your own parameter.
6 parameters.
Please come.
My lord, if I may just buttress on the additional point, my lord,
multiple choice.
My question serial number is C. Distinction between the language Bengali and English. The question which has been formulated by lordship on this point, my lord. If your lordship please to take that question, my lord, for one.
number item
2104.
No, he's not going there, and the court doesn't have the file. The file is the one which is there in the board, serial 14.
I am only impressing upon your lordship regarding the questions which has been formulated in 2 different languages.
Yes.
My lord, in Bengali, it talks about তাপবিদ্যুৎ উৎপাদন জলবিদ্যুৎ উৎপাদনের চেয়ে বেশি উপস্থাপন যোগ্য কেন? And my lord, in English, it is said why it is easier to set up a thermal power plant compared to a hydel power plant. Now, my lord, 2 different occasions. One is when you are talking about upasthapan yogya. If you make a literal translation to English, it talks about presentation. On the contrary, when it comes to English, it talks about setting up a power plant altogether. It's 2 different questions in 2 different languages. Now a person selecting a language to given.
Sir, it's impossible for the court to decide all this.
My lord, for that reason, my lord, even when the question answer was published, my lord, I have raised the categorical objections that have not been considered. That is my limited prayer. At least in the parameter of the distinction between the language, that should be taken into.
Kindly, before your lordship, I'm giving my learned friend, I have to redact a portion of this email. Kindly see, this is the email sent to all experts. I'm reading it for my learned friend's perusal also.
No, he has it and he knows it, and you showed this earlier also.
Yes.
These are the parameters on which how the experts check.
Not grievance, but the choice.
No, he is aware.
All matters.
In all matters.
All matters. This is the common email.
And see,
these issues, grievances that none of the choices in preliminary key is correct, and grievances that more than one chance in the preliminary key are correct too.
Yes, second one. And see at the bottom, just prior to the regards, the question booklet, preliminary answer key.
The syllabus are being attached with this mail for your kind perusal.
But the authentic documents which the candidates are relying upon, were not forwarded. So the expert doesn't know what the candidates read and relying on which they marked the answers. The candidates were supposed to file two authentic documents. According to the commission, the authentic documents were required to be given so as to dissuade others from filing all these objections, right? Because that cannot be the only logical reason for telling them to file so many.
In terms of our rules,
Whatever. লিখুন তো
Supplementary affidavit regarding the transfer.
yes, supplementary affidavit filed by the petitioner in court today be written with the records. Let copy of the same be circulated.
Deficit court fees.
Acha, receipt showing payment of deficit court fees be also written with the records. Stop. আমাদের challenging the mode of assessment of answers একটা order আছে. Do you have any similar order that is passed? Mr. Singh, please pass on.
কালকে হয়েছিল না?
That was pursuant to the earlier direction of the court. There is a report filed. There is a report filed. No, yesterday, day before yesterday, matters are being adjourned due to pendency of the division bench appeal.
On 23rd of March.
Yes, you have any order? Give, so I won't pass any fresh order. The same can be given. Add to that also there are orders. Check করে দেখে নেবেন division assessment of answers.
Kindly direct them to file a report in this. In the meantime.
And the matter has been adjourned due to pendency of the appeal.
My lord, an item number. Item number.
I'll go one by one.
Will be tagged along, my lord. Similar fate will be covered.
No question of tagging. Wait. Yes, call 15.
23 March. 15 similar order can be passed, my lord. This is
Same
different
question.
subject. No,
Different question.
different subject also, my lord.
Different
One
subject.
petitioner. My lord, 4 questions, my lord, similar order can be passed.
All right, same order will go down. Deficit court fees will not
No,
be there. Supplementary will be there.
No, this is English, my lord. Subject is English, so there is no Bengali part.
Affidavit of service is there.
এটা একটা কোড ফি চলে এলো, এটা কোন
16.
16 is will also same.
Same. What are you giving?
No, payment of deficit court fees and the affidavit of service.
Acha, payment of deficit court fees and the affidavit of service and no supplementary.
The same, my lord, payment of deficit court fees and affidavit of service.
Yes.
কি নাম 17 এর নাম কি
Deacon Roy.
Payment এ যাবে তো?
हाँ वो next.
18, my lord, supplementary affidavit is there, my lord, getting the translating part, my lord. And deficit, I have paid the deficit court fees.
Supplementary affidavit and the deficit court fees and the affidavit of service. Otherwise, the order remains the same.
Affidavit of service to যায়নি এটাতে।
5/40/2026
নেই।
Same order?
It is 17 years. 17.
একটু টাইম দিন, কোর্ট ফিসটা দিয়ে দিন, একটু টাইম দিন। আচ্ছা
The rest of your matters will not be listed. All right, because the same order is being passed, so we'll wait for what the division bench's outcome is. Thereafter, those will be listed. No further orders.
There are some matters where my lord, we have not challenged the question. We have stated there are printing mistake. My lord, those can be taken care of, my lord.
No, let the division bench pass order, we'll see.
Target. Taken.
Number 20, my lord, affidavit of service and payment of exit.
There is a supplementary affidavit also.
21.
Supplementary affidavit.
Only one in legis, my lord. In item number 19, there is a supplementary affidavit I have missed.
All right. 19, there is a supplementary affidavit. 21,
Payment of deficit court fees and the affidavit of service, and this is the supplementary affidavit.
supplementary deficit court fees affidavit of service.
Obliged.
এগুলো আমরা দেখছি না কিন্তু এগুলো আমরা দেখছি না কতদিন পিটিশনার
Call 22, 22,
Item 22, my lord, we have challenged the vice of 2025 rules, which was my lord framed after my lord 2016 selection was set up not by the Honorable Supreme Court, directing that there should be fresh recruitment process in terms of the vacancies arose because of the cancellation. That's one of the fundamental points we are urging. This is with regard to my lord non-teaching staffs. Kindly turn to page 131. And another peculiar-
non-teaching, when was the recruitment notice published?
Look, this, I just give it a in the month of
9th August 2020.
yes.
Why are you coming now?
Paragraph 17.
Now, my lord, after the examination has been concluded, I am challenging the violence of the rules. It can be done at any point of time.
No, you have applied in the process.
But this result was notification was 9th October, not August.
No, rules 29th August. Advertisement.
Notification. Now, my lord, kindly comes to a very interesting stage how these manipulations are made. Kindly turn to page 131. Though my lord, similar petitions are pending, I must confess your lordship will add the occasion to move.
Yes,
Kindly turn to like page 131, schedule 2.
7650.
yes,
My lord, similar experience, let part A, B, academic qualifications including professional qualification 10 marks, similar experience 5 marks. What does it mean? As vague as it could be. So these are the, my lord, the areas where from my lord, the all mischiefs are done and sought to be done. This is one of the ground. Another ground was that by a subordinate rule-making power, you cannot negate a Supreme Court judgment, even the High Court judgment. These are 2 points on which your lordship on the earlier occasion was pleased to ask them to file their affidavit. Those matters are coming on 25th of February. But here, my lord, I would be seeking a small interim order that this allotment of 5 marks, my lord, should not be done without the leave of the court.
what is the stage of the recruitment process?
The written examination is over.
No.
Only over.
First of March.
It is fixed on 1st of March.
All right.
First and 8.
Huh?
First March.
First March.
There are written examination is yet to. We are in the process, my lord, of shortlisting the applicants and everything. Now, my lord, there is a similar petition which was taken up. WPA 27650, where we have our opposition also
Opposition has been filed?
in that matter.
Yes. If it is challenging the same rules, then
Yes, kindly permit me, my lord.
maybe the ground of challenge is different.
My lord, please see.
Players.
My lord, kindly see the prayers in that matter. I am
Yes, the
reading.
same, the grounds are different.
Declaration declaring the such rules 4/8/2025, non-teaching rules 25, ultraviolet. And my lord, to cancel, resign, withdraw the route, cancel and pause the notification dated 9th October, that is the advertisement.
Lord, I am told, my lord, subject to correction by Mr. my junior friend, Bhattacharya, the matter is coming on 25th of February.
Alright.
After affidavit. Lord,
Affidavit.
this may be, my lord, tagged with that, but these are the independent, Lord,
Ground. The ground is different, you say. Please come.
My lord, I appear on behalf of the state, my lord, since they have challenged the virus of the things, my lord, let them serve coffee upon the learned advocate channel, my lord.
They will serve.
and Lord, which was long due, my lord, that was the, as per the Supreme Court, publication of, my lord, Wema sheets of 2016. That's also not been done. 131 chole hai?
West Bengal School Service Commission.
131.
Bracket open, selection of persons for appointment to the posts of non-teaching staff. Bracket close rules, comma 2025 is impugned in the instant writ petition. Stop. The selection process is ongoing. Stop. The written examination is yet to be held. Stop. Prayer has been made to pass interim order restraining the authority from awarding marks allocated for similar experience.
দীপ্ত প্রত্যেকদিন আলাদা আলাদা পার্টিকে দিয়ে এক একটা করে মামলা করার বদমাইশ ছেলে।
Yes, it has been brought to the notice of the court that a separate writ petition challenging the same rule is due to appear for hearing shortly. Let the instant writ petition be tagged along with, give me the WPA number, please.
No, 27, the other one, 27650. Suparna Das.
27650.
Of 25.
That's it. So the respondents will be at liberty to file opposition to the instant writ petition. Next. The
point of saying algorithm factually.
As the recruitment process is at a very preliminary stage, comma, the court is not inclined to pass any interim order in this matter at this stage. Stop. It will be open for the petitioners to file appropriate application seeking interim order as and when necessary.
কবে আসবে রিটার্ন হবে?
Your Lordship has been kind enough to keep it along with the other matter.
Along with the other matters.
Only one thing, with my learned senior's permission, the other matter is coming up on the 25th. If your Lordship wants an affidavit by 25th,
You say check up. If you see that the no further affidavit is required, do not file. Because point of law.
হ্যাঁ এই মাসে 25th আসবে তো, তাই তো? এই মাসে 20। তাদের মামলা আছে।
এরকমই হবে, আপনি পাঠান, আমি চেম্বারে দেখে নেবো।
I'm for the state.
Yes. Sanctioning of post of education in such and such school.
Right. I can send the recommendation 2020
2020 recommendation.
Commission of School Education. At least the administrative transfer may be affected to other schools. Because it is public education.
Yes. Then what is the use of transferring a candidate over their teacher? It is recommended to the commission.
Commissioner, madam, Commissioner School Education, so that
Then commissioner will be your client. Why don't you take instruction? What is the further step?
not got the brief even. I don't know the matter is coming today.
Why? The order was passed on 5th of February. It is, you must be put on notice.
But,
Obviously, without the notice,
next week, my lord, I shall take instruction.
learned advocate representing the state respondents seeks time to revert with instruction from the Commissioner of School Education as regards the steps taken to re-recommend the petitioner in a school where there is a vacant post in the subject education.
Another thing, in this meantime, I tried to bring any school which has got a vacancy clear cut and also the post sanctioning memo for education. I have filed one supplementary, affirmed one supplementary affidavit to that effect. Mentioned one school. I'll be just handing up to my learned senior one copy of
Yes,
this.
supplementary affidavit.
Dear my lord, I have stated-
Supplementary affidavit filed by the petitioner in court is taken on record.
Here, my lord, I
Let
have
a
stated.
copy of the same be served upon the learned advocate representing
Here
the state respondents. And the commission also, commission is here.
Yes.
And the commission.
So there, my lord, at paragraph number 10, I mentioned the school. Kindly, my lord,
Acha.
paragraph number
The
10 of the
petition,
supplementary.
in the supplementary, in paragraph 10 of the supplementary affidavit, comma, the petitioner has disclosed the name of a school where there is a vacancy in the subject education. Stop. Learned advocate for the state respondent shall revert with written instruction from the Commissioner of School Education. Released on 9th of March.
Grateful.
Obliged.
Well, I am for the petitioner.
Yes.
My lord has directed us to file additional affidavit, my lord, to see the medical reimbursement claim of the petitioner can be released as per the rules and all. We have filed an additional affidavit, my lord. In the additional affidavit, page number 15 is the relaxation of the rules, my lord. Additional affidavit of reply on behalf of the
Yes.
Lord, Rule 15,
Yes.
Lord, Clause 3 says, page number 15,
Yes.
relaxation rules, Clause 3. There is no limit on the amount that can be reimbursed, but individuals feeling prescribed for various items of treatments under different systems of medicines have to be applied.
Why are you showing this rule to us?
Lord, because Lord, in terms of the tariff which has been prescribed, the treatment of dental treatment held to be under the CGHS tariff is not covered, Lord. That's why the payment was not made. And for the
Now you want to relax the rules? You want to invoke this provision?
Lord, as my lord has asked on earlier occasion, you just check it the rules whether there is any provision to relax.
You can invoke this rule and see how the petitioner can be reimbursed.
My lord may pass an order in terms of clause 3.
Why the requirement? There is a requirement of the court passing an order. You suo moto invoke your rules and pass order.
May I submit one thing, my lord?
Yes.
My lord, page 8 may be seen, my lord.
Page 8 of
The affidavit filed by the respondent.
additional affidavit.
Yes, my lord.
Yes.
Last order passed by your lordship.
Yes.
Page 8, my lord.
What do you want to show from here?
The order passed by your lordship last
Yes.
time.
Yes.
That order I want to show, my lord. My lord, this treatment is not available in Andaman Nicobar Islands.
Yes. The court is aware.
That is the reason I was referred to mainland. And it was certified by the head of the department also.
Government doctor.
Yes, my lord.
Right. Contender.
Clause
The client thinks that the court will take the issue lightly, then your client is highly mistaken.
Absolutely not, with that way we are comprising the facts before the lordship.
If you feel any rule is required to be relaxed in the facts and circumstances of the case, the decision is yours. The court will only see whether the bill of the petitioner has been reimbursed or not.
On that occasion, last occasion also I submitted, ma'am, because my lord, as to the rules, if it is relaxed also, my lord, it not come under the purview, my lord. So that is a difficulty. I had said, my lord will pass an orders that it has to be released, not treating to be as a precedent, my lord, we will consider and we will release, my lord. Because the authorities are not denying to that extent, but because the rules, even if clause 8...
whether it will be treated as a precedent or not is the next thing. First you release, thereafter the court will see what is to be done.
Pass an orders to that extent, my lord.
Yes?
Lord, may kindly pass an order to that extent, my lord, because...
Order is already there. How many times order will be passed?
Lord has said verify the bills and release the reimbursement has to be released, my lord. In terms
Right.
of bills have been verified and as per the rules, my lord, that treatment which he has done, it is not covered under the CGHS scheme, my lord.
What could a patient do if the treatment was unavailable in the islands and the petitioner and the patient was referred to the mainland? The bills were checked by the government hospital and approved. Now you say that the treatment you cannot reimburse.
No, we cannot say reimbursement, Lord, because same my lord has passed an order to reimburse the medical bills. Lord, in terms of reimbursement, as per the medical rules, only it has to be reimbursed, my lord. Because medical
If
bills...
you intimate the patient that see this is your ceiling and you cannot avail this type of treatment.
My lord has passed an order whereby my lord has said they have to be treated at par with equivalent to the regular employees.
Right.
Medical reimbursement, whoever entitled for the regular employee, the instant retired pension is also to be entitled. Yes. We have treated this instant petitioner's case along with the regular employees. What are the entitlement of the regular employee who has been entitled release that was released to this petition also in terms of the CGS's tariff rules. But this is a difficulty, I again, board or lordship, we are not taking the orders as lightly, but subject to lordship consideration, because what the rule says, the regular employee, what they have been entitled, that as same has been paid to these also. We have cross checked to the pay and account also. Pay and account also inform the same facts now.
Petitioner, just tell me, are the regular employees getting the same reimbursement?
Yes, my lord.
Yes means 44,000 has been paid to you, and you say this is proper?
No, that is not proper, my lord, because I spent around 6 lakhs on the odd amounts, my lord.
I understand, but if it is not permissible, they say, according to the rules, then under which provision do you claim this money?
If there is no treatment is available in Port Blair, my lord,
maybe the treatment is not available, but the bills, the difference in the amount is so high that the authorities are unable to pay.
My lord, this is nothing, my lord. For open heart surgery also they used to pay the entire amount.
Well, open heart surgery or what, the court is not concerned. Thing is, for the in accordance with the rules, whatever is payable has been paid.
My lord, kindly accept one submission, my lord. There is no provision for claiming any medical reimbursement for the pensioners, my lord. Based on the judgment of the Honorable Apex Court and this Honorable Court, the payment.
Exactly. So the you were not supposed to receive anything. Now you have received 44,000. If you are aggrieved, then I give you leave. You can file fresh writ petition and get it done.
Well, another 10 years it will take. Already I am 76.
Yes, it will take. But then if the rules does not provide, then how much can the court relax the rules? To some extent it can be, but 44,000 and 6 lakh, the difference is huge.
That is the amount I spent, my lord.
Nobody is disputing.
My lord.
Nobody is disputing that you may not have spent that much of amount, but how much can be reimbursed by the authority? How much reimbursement can you seek from them?
My lord, that is one thing at the cost of repetition, my lord. I am again repeating, my lord. There is no provision for pensioners. Based on the judgment of the Apex Court and Honorable High Court, my lord, the claim was settled. In the judgment, my lord, passed by the Honorable Apex Court, it was very clear, my lord, the entire amount was given. Sivakant Zai versus Union of India and others, my lord.
Yes, and what was the difference in that matter?
In that matter, my lord, pensioner, my lord, no amount was given. He spent around 4 lakhs 99,555. The Supreme Court directed to reimburse the entire amount.
You want to go to the Supreme Court, so you can go there and get it done.
No, my lord. I cannot go, my lord. I am already 76, my lord. How many days I am going to live? I do not know.
It is Mr. Prashant who will be going and not the petitioner, not Mr. Hanif.
My lord, it is very expensive, costly affair, my lord, to go. Not
but the figure is also quite high.
Not possible, man. I will leave it to your lordship, my lord. Whatever your lordship deem it fit, my lord, kindly do it, my lord.
To what extent can it be relaxed? The contemner, can you please say?
No, that's why, my lord, after page number 10, we have invoked the relaxation clause. The bills have been forwarded to the pay and account office also, my lord.
Right.
We also find that after the sealing, they come to know that the amount which is done by the contemner is entitled for that amount only. You know. That's why I showed lordship the relaxation.
44,000.
This is my humble submission.
This is the figure. 44,708.
It is again rechecked to the pay and account office. It was sent whether any relaxation clause was there so that it can be relaxed and he can be reimbursed for that.
Yes.
And also invoke the clause 8 of the rules, my lord, and then also they find that the treatment which he has done as an outpatient, so that is not been, he is not entitled for that amount.
And in thing is, if the treatment is not available, then The patient, you cannot expect the patient is going to die over there without any treatment.
It is right, Milord, because it's a dental treatment, Milord, and that to be as an outpatient for that period, he has been treated, Milord. And the admissible, which is be permissible under the rules, that has been calculated and the details have been given and he has been reimbursed. Milord.
What to do? Peruse the additional affidavit filed by the contemner. Stop. It has been mentioned that the admissible amount that is payable to the petitioner of rupees 44,708 has already been disbursed, and the reimbursement for the sum of rupees 6,86,006 cannot be made in the absence of supporting rules. Stop. Paragraph. Whether the petitioner would be entitled to complete reimbursement of the medical bill has to be adjudicated in a fresh proceeding. Stop. Next. Since we find that there has been substantial compliance of the order passed by the court, the court, there is no requirement of proceeding with the contempt application any further. Stop. The contempt application stands disposed of. Stop. It will be open for the petitioner to challenge the action of the respondents in a proper proceeding in accordance with law.
And I am permitted to leave, Milord.
My lord, in the unavoidable circumstance, I mentioned on matter number 508, 70 years old lady may not get another gratuity amount, only gratuity amount. 23, order was for 10th October 2023. But still, last occasion I also mentioned, my lord,
Other side.
Mr. Subroto Ghosh, my lord, he has.
Municipality.
Yes, any time you will fix, I will have notice, my lord.
এটাকে পরের দিন দিয়ে দেবেন তো উপর দিকে। Please intimate him.
Yes, yes, my lord. I went to
এখন প্রেজেন্টে
Personal appearance. Years. Personal appearance.
293 marks.
293. All right, wait, I'll take up the Jalpaiguri matters. Yes, call Jalpaiguri.
I mean, item number 1, my lord, content number 13, the present chairman of the municipality.
Order complied?
No, no, ma'am.
No?
My lord, can.
Item number 9.
JPT চলছে
Item number 1, my lord.
Yes.
My lord's order, last order, my lord, 4th December 2025.
Yes. What was supposed to be done?
And it was a matter of illegal construction, my lord.
Illegal construction. Yes.
Has been-
Municipality. Illegal
Yes, my lord, on
construction
last,
issue.
yes, my lord, on last occasion, the council of the erstwhile chairman has submitted that the order was complied with. But on our municipal records, we do not have any documents to show that the order was complied with. My lord may pass necessary direction so that we can go forward and comply this order.
My lord, paragraph 7 of my lord's order, kindly, ma'am.
Learned advocate representing Mal municipality seeks extension of time for complying the order passed by the court. Stop. In view of such submission, hearing of the contempt application stands adjourned till 23rd of April 2026. Stop. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
23rd April.
Yes, my lord.
Next. Item 3.
Your lordship, I am with the petitioner lordship. Till date, order is not complied, lordship.
My lord, on the past occasion, my lord, learned advocate appearing on behalf of the state submitted that they have forwarded the transfer application to the School Service Commission. But in the School Service Commission, there are no, my lord, application for transfer, my lord.
Pending.
Therefore, my lord, pending, my lord. Therefore, my lord, chairman of the commission directed the school, district inspector of school to forward the transfer application so that your lordship's order may be complied.
No, lordship, on 6th February 2026, the DI forwarded all the documents to the SSC lordship. And that communicated to the petitioner lordship.
Where from did you get to know?
The DI says forwarded a copy to the petitioner lordship.
All right, please come.
Even if, my lord, SSC is, chairman of the SSC directed to forward, it is the duty cast upon the district inspector of school to forward this application.
Learned advocate for the commission relies upon the communication made by its chairman dated 21st January 2026 calling for the transfer application of the petitioner which did not reach the commission. Stop paragraph. Learned advocate representing the petitioner submits upon instruction that the district inspector of schools forwarded all documents to the commission. What is the date you said?
6th of February, lordship.
With a communication dated 6th February 2026.
Lordship, my lordship, the several communication have been made, lordship. It is here, lordship, that office memo 9th of June and 10th of September, they all documents forwarded to the SSC lordship. This all have been
Do you have a copy?
I have supplied to the petitioner lordship.
You supplied to the petitioner? Supply a copy to Mr. Roy who is appearing for the commission.
Lordship.
Alright, so that Mr. Roy can forward it to his client.
My lord, kindly direct the state respondents so that the district inspector of school may be directed or requested to forward the.
He has already forwarded.
If he has not forwarded.
6th of
Yes, lordship, he is already forwarded.
Acha.
Probably, my lord, it was returned to the office of the School Service Commission, my lord, and because 8th of August 2025, my lord, kindly I have handed up a document on my lord.
Yes.
Last occasion, kindly see.
I see 8th of August.
So, my lord, it was returned to the district inspector of schools.
No, 6th of February it has been sent. Acha. Well, let a copy of the communication made by the district inspector of schools on 6th February 2026 be handed over to the learned advocate representing the commission for onward transmission to the chairman of the commission. Stop. Released the matter on 23rd of April 2026. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
So can it be March lordship any day?
How long will it take?
1 year only. Use the is suffering from medical emergency lordship.
Commission will take 2 weeks.
Yes.
After receipt of this, all these.
Yes, it has been, in that case, please prepone the date. Make it on 9th of April. Yes.
This is my exception of the compliance report filed by the contender number 1 and 2. Alert.
Yes, Mr. I am on board the contender number 1 lordship.
Alert. If your lordship kindly have a look the compliance number 2. This is the Pradhan. He very clearly stated that the compliance the order for pastor lordship. And there is no construction or lifting of earth has been made government land by the private respondent. Now, if your lordship kindly have a look
to the affidavit of compliance.
Affidavit of compliance filed by the respondent number 2. Lordship got it?
ये অনিমেষ বাবু এফিডেভিট অফ কমপ্লায়েন্স কি জলপাইগুড়ি photographs?
Yes. Photos only. Prior to that, my lord, I am reading, my lord, the compliance paragraph number 3. Only this, my lord.
You have a copy?
Yes, my. We have served.
Yes.
Very dearly, she stated by affidavit that there is no construction has been made. And no encroachment has been made by the private respondent. Now, my lord, kindly have a look, my lord, my exception. Page 12.
Yes.
Immediately after filing this writ petition, the concerned assistant engineer write a letter to the IC as well as the Pradhan that the lordship kindly have a look, page 12. Last paragraph. That there is an encroachment and construction is going on inside of the government land by the private respondent. Now, my lord, after onwards, my lord, page 13. This is the photographs inception at the time of filing the writ petition. The lordship kindly have a look. Thereafter, my lord, last, my lord, page 14, 13, 14. At present status of the land.
Who is the contender number 1?
Contender number 1 is the assistant engineer. He only stated that by his compliance report that we have sent the order passed by your lordship. And
no, this that you are relying upon is of the Pradhan.
Yes.
Of the Gram Panchayat.
Gram Panchayat.
Pradhan said that there is no
construction,
but the engineer is saying there is construction.
Yes.
Which respondent is the engineer?
Assistant engineer respondent number.
In the contempt.
In contempt, my lord.
Condemned.
LS committed one lawsuit. Lawsuit the direction was spouse lawsuit. The matter communicated to the Pradhan lawsuit. I communicated to the Pradhan lawsuit and the Pradhan take appropriate step. But the land in question belonged to the Pradhan lawsuit. The not government land lawsuit in the.
It is Satai Pradhan.
Pradhan means Pradhan is the panchayat land?
Yes.
Panchayat land total lawsuit. Not PW land lawsuit.
May not be PWD land, but if it is a panchayat land, then it does not mean that the private party can do anything over there. What is the assistant engineer doing?
The direction is given to the Pradhan lawsuit to remove the construction and encroachment lawsuit. I am not representing the Pradhan lawsuit.
You are representing the assistant engineer, and the assistant engineer should take steps if the government land is illegally encroached upon by any party.
And not only my left side portion, they have also encroached the right side portion of the said land.
Who is appearing for the Pradhan? Where is he? Where is he?
I don't know.
I have sent him a copy of my exception through his email.
Please come. If it is an opposition filed by
the issue against the my lord contempt, otherwise they will not comply with your lordship order.
Filed by the petitioner to the affidavit of compliance filed by the contemners is taken on record. Stop. Paragraph. Learned advocate representing the petitioner draws attention of the court to the communication made by the assistant engineer, Dhupguri Highway Subdivision on 7th April 2025 to the officer in charge, Dhupguri Police Station, intimating the police that illegal construction and filling up of earth on the government land in the left side after Daukimari Market, page 12 to dekhe neben to, on Dhupguri Nathua Road was going on within the right of way of Dhupguri Nathua Road. Stop. The police was requested to take necessary action to stop encroachment of government land immediately. Stop.
Lawsuit, at the time of filing the writ petition, they alleged that there is an encroachment. That's why this memo was issued to the officer in charge lawsuit. At the time of filing writ petition lawsuit.
The from the affidavit of compliance filed by the